Speaker.
Dennis O'Rourke.
Mr Speaker, the Parole Extended Supervision Orders Amendment Bill makes two main changes, both of which are common sense. It allows extended supervision orders to be renewed as often as is needed, and it will mean that the Act will now cover high-risk sex offenders against adults and also very high-risk violent offenders. It clarifies the criteria to ensure that only the highest risk offenders are eligible for these orders, which would allow them then to live in the community but under strict supervision, but also with the protection of mandatory court reviews. New Clause 12 of the bill lists behavioural characteristics of an eligible violent offender indicative of what is called severe disturbance in behavioural functioning. New Zealand First, Mr Speaker, supports this so that the courts will have the guidance needed in making an order, noting, of course, the specific context for an extended supervision order as distinct from a public protection order. Overall, Mr Speaker, these are very good amendments to the Parole Act, and New Zealand First supports that bill. New Zealand First will also continue to support the Public Safety, Public Protection Orders Bill. It achieves a very difficult balance between protecting citizens from serious sexual or violent harm from people who are likely to reoffend following release from prison, and of course the rights of those affected by the order to be subject to the least restrictive form of detention that might be practicable. It also ensures adequate oversight of detention through regular reviews by a review panel and the High Court, an independent inspector and ombudsman visits, and by an annual report to Parliament. These orders observe the four important principles which are set out in the legislation. Firstly, PPOs are not about further punishing offenders, and the offence is to be only one of several factors that are relevant to assessing whether there is a very high risk of imminent sexual or violent offending. In this respect, I would have to disagree with Mr Clendon, who says that if a person is released from prison and might be found to be possible of reoffending for the same sort of offence, then they would be being punished again under this legislation. That actually isn't true. The reason they are being detained is to protect them and the public from that likely reoffending. And I would draw a comparison, for example, with a prisoner of war. You know, these people are detained, but they're not being punished. They are simply being detained because they are to be prevented from rejoining the fight. So they're not being punished. There are reasons for detention other than punishment, and this is one of them. And that reason is to prevent reoffending, which is actually for the benefit of the offender as much as the public. So I think Mr Clendon and the Greens have got that wrong, and they need perhaps to give that some more thought. The second principle is that a protection order should be imposed only if the magnitude of the risk posed by the respondent justifies that. And thirdly, an order will not be imposed on a person who should be detained under the mental health legislation. And most people who are in this sort of position will probably be detained under that legislation and not under a public protection order. There are likely to be very few who will need to be detained in that way. Fourthly, the fourth principle is that persons who are detained in a residence should have as much autonomy and quality of life as possible, and that is of course consistent with the proposition that they are not being punished, they're simply being detained for their own good and for the good of the public. And there must be a thorough assessment as to whether a person is likely to offend again in terms of sexual or violent reoffending. And it has to be found that the application is supported by at least 2 psychologist or psychiatrist reports, and the court may call for an additional report, and the respondent also can call for another report. And those, I think, are very good safeguards. It means that the court will have very good information upon which to base its decision. The crux is that there must be proof as to whether an order is necessary, and the court must not find that there is a very high risk of further offending unless it is satisfied that the respondent exhibits a severe disturbance in behavioural functioning, established by evidence of specified characteristics to a high level. So this is a very high bar to reach in evidential terms. Mr. Speaker, concerning the review provisions, a court reviewing a PPO must consider whether the subject still poses a very high risk of imminent sexual or violent reoffending, taking into account the reports that would be provided to it. And if the court finds that the person no longer poses a very high risk, it must make a finding to that effect. And the court must then cancel the PPO and, if justified, impose a protective supervision order on the person instead. New clause, subclause 81B, would require the person to be released from detention as soon as practicable after a protective supervision order was imposed. I'm also gratified to see new clause 124B, which inserts subsection 41CA into the Legal Services Act 2011. And that would make any proceedings under the Act a specified application, which makes it easier for the person concerned to access legal aid than it is for standard civil proceedings. And at the select committee stage, I was very keen that that be put in the legislation, because I felt that if a person was to be subject to an order of this kind, then it was essential that they could easily get legal aid with which to defend themselves, and therefore the balance between personal rights and those seeking to detain that person would be well preserved. Another welcome addition to clause 31 would allow visits from permitted persons, subject of course to appropriate restrictions, and new subclause 1A would permit a visit to be unsupervised if the resident manager considered that that would assist in rehabilitation. But new clause 56(1)A requires a residence manager not to allow a person under the age of 18 to visit unless, again, it can be shown that that would assist the person's rehabilitative needs. So rehabilitation is also an important part of this. And Mr. Speaker, one of the most important new sections is new clause 124A, which adds a new subsection to section 121BB of the Crimes Act, making it an offence to escape from the residence for a public protection order. Mr. Speaker, the bill also provides for inspections of residences, and an inspector can arrive unannounced at any time for that purpose. But the bill also confers jurisdiction on the court to order that a person be detained in a prison instead of a residence if it is satisfied that the residence detention would pose an unacceptably high risk to the person or to others. So again, there's a good balance there. Overall, Mr. Speaker, New Zealand First welcomes the legislation, which we think fairly and effectively fills the gap in the law to prevent very dangerous people, and there would be very few such people, from being free to reoffend again upon release from prison. And I want to emphasise once again that this form of detention cannot fairly or properly be regarded as a form of punishment. It is only if it is really necessary for people who are so dangerous that they would be a threat not only to themselves but more particularly to the public at large. And there have been cases of that in recent years. This is a gap which needed to be filled, and this legislation does it.